Alrighty, if you haven't done so already, please put your name and agency in the chat, and we will go ahead and get started. I'm Bella Kurtz. I'm with Kansas Statewide Homeless Coalition. Today we have Andy Kent from Kansas Legal Services. Andy earned his bachelor's degree in writing from Dickinson State University in Dickinson, North Dakota. In 2009, he then went on to study at the University of Missouri, Kansas City School of Law, graduating in 2015 with an emphasis in urban land use and environmental law. In law school, Andy was a member of UMKC's team for the National Environmental Law Moot Court Competition, served on staff for UMKC Law Review and the Urban Lawyer, and completed internships with Legal Aid of Western Missouri and the EPA Region 7 in Lenexa, Kansas. Andrew served as assistant city attorney for the city of Leawood, Kansas from December 2015 until May of 2019. After Leawood, Andy joined the Unified Government of Wyandotte County, Kansas City, as prosecutor working in the Kansas City, Kansas Municipal Court. He joined Kansas Legal Services as a staff attorney in September of 2023. At KLS, Andy practice areas have focused on assisting individuals recovering from substance use and mental health disorders, advocating for individuals and families struggling with housing, and debtor defense. Today, Andy's going to be talking to us about medical debt collection. So, Andy, take it away.
Thank you very much, Bella. Good morning, everyone. As you can probably hear, I'm a little scratchy. I was in Washington, D.C. over the weekend to celebrate my younger brother's 30th birthday, and 6 million people there. It's a little more packed in. I may have picked something up, or I'm super allergic to something out there, and it's just sort of recovering. If anyone has a hard time hearing me or understanding, please use the chat, and I can try to answer questions as we go. I'm happy to be interrupted. So don't feel like raising your hand or speaking up is something that will throw me off too far. As Bella said, we're going to be talking about medical debt collection, specifically here in Kansas. I'm a member of the Wyandotte County Debt Relief Project. We have 2 staff attorneys, a paralegal, and an intern, and we are focusing heavily on medical debt for residents of Wyandotte County, though I do know that we're looking to expand that into other areas of the state. So just a brief introduction for, well, where'd my mouse go? There it is. Kansas Legal Services, I think most people here probably know who we are. We're Legal Aid in Kansas. These are our 4 areas of probably the primary focus of our practice areas. Things outside of this, though, we can still address. At the end of the presentation, there'll be information on applying and all that kind of stuff. So let's jump right in. By the numbers, medical debt in Kansas, the Kaiser Family Foundation estimates that up to 41% of American adults owe some kind of medical debt, whether it be dental or vision or actual hospital or doctor debt. And a recent survey from the Consumer Health Experience State Survey, it was 1,400, so it was kind of a sampling survey, found that nearly 3 out of 4 Kansans have experienced a health affordability burden in the last year. And what that means is I'm not paying for something else in order to pay something else that I need, food, rent, utilities, whatever, in order to pay off a medical debt. And they broke these numbers down a little further. Those making less than $50,000 a year was about 42% of individuals. We're having to sort of play that debt juggling game or that bill juggling game where you're skipping out on one thing at the beginning of the month, hoping to catch up on it at the end of the month in order to pay a medical bill. And I included the 50K to 75K a year, just because as that percentage starts coming down, those numbers really grow up. And when you're talking about making more than $100,000 a year, those folks are very rarely experiencing this kind of issue of balancing your budget, but not really balancing it. And the Kansas Health Institute reports that 3.4% of individuals in Kansas are in some level of collections. Now, that doesn't necessarily mean that they are being sued. It could just mean that the collectors are calling, but 3.4% of Kansas are currently in collections for medical debt. There's a really great website that I didn't have space to link here called the Urban Institute, and they break it down county by county. And so as I've been working on the Wyandotte County stuff, I was curious. I pulled that up and I found that it's about 1 in 3 individuals, a little more than that actually. It's 35% of Wyandotte County residents are currently in collections for a medical debt issue. And the Urban Institute, if you just Google it, you can find their map, sort of a heat map of the whole United States. You can break it down by county, you can break it down by state. It's a really cool tool to try to understand where maybe the biggest needs are. So with that, I'm going to talk about 2 different things today. There's for-profit and nonprofit, and there are really important distinctions between those two. Basically, nonprofit hospitals have certain requirements, whereas for-profit hospitals are just like any other business. It's like going down to Macy's, or I know people don't really shop in brick and mortars anymore, but getting that credit card, and they can collect in pretty much any way that you would collect any other debt. There's no special defenses, there's no special requirements for them, and we're going to break it down between those two. But first, we're going to tackle the nonprofit hospitals. Most of the big hospitals in Kansas are nonprofits. Think KU Med Center, Stormont Vale. What's another one? Providence Medical Center, which I think has recently been acquired. But these big hospitals in Kansas, or sort of your regional ones, Pratt Regional Medical Center is one that I'm pretty familiar with. Those are community-owned hospitals, which are 501c3 nonprofits. And they are governed by another section in 501 called 501R, and it restricts how they can collect on these debts. The most important component for a nonprofit hospital, or for these bills that are coming from nonprofit hospitals, is that they must offer what's called a financial assistance policy, which triggers charity care. And charity care is essentially free or discounted care based on income level and ability to pay. And it does not account for whether or not you have insurance. If you're on Medicare, Medicaid, none of that really changes an individual's eligibility for charity care. It can be used to discount those copays. It can be used to discount hospital charges. And basically, when you kind of go in and you read the regulations and you read some of the sort of supporting documentation about it, it's basically the hospital is getting this great thing. They don't have to pay any taxes. But what are they doing in exchange for that? And the exchange is the charity care program. So the financial assistance policy is basically guidelines that the hospital will use to determine who qualifies for this charity care. Typically, it's about 200% of the poverty level, but they can have different levels. It's not necessarily an all or nothing. It kind of allows the hospital to tailor it to the needs of their community is the theory behind it. And as I said earlier, it doesn't always mean that your care is 100% free. It can just be discounts. We give a 25% discount or 155% discount, or whatever. And typically, you're going to see that it requires a proof of income or a lack thereof. They're going to be asking for pay stubs. They're going to be asking for tax return information and things like that. And when the point of the financial assistance policy is to inform your patients that this thing exists, this charity care is there. I'm kind of going off on a tangent a little bit, but we've had some litigation in the state around whether or not the hospitals have been properly notifying folks that charity care exists. And in some of our cases, it turns out that almost nobody knows that this charity care option exists. They may have you call a number for help with billing or what have you, and they don't bother to mention it. They don't give you a copy of it at admissions. And all of that kind of ties into some sort of defenses you might have when you're being sued for a medical debt. Specifically, before they can sue you, they have to engage in an affirmative step. So as you can see here, there are certain things called extraordinary collection activities. And what are ECAs? They're lawsuits, garnishments, liens, anything that sort of happens outside of the basic sort of conversation between you and the billing department. It was interesting. I was at a conference earlier this year, and I learned that some states you don't need a lawsuit to get a garnishment. Kansas is not like that. In order to garnish wages or to garnish in bank accounts and all that, you have to have a judgment. But out east, there are some places where you don't even have to do that. If the person doesn't pay, they just sign a garnishment, and that's it. It's sort of a totally administrative situation. So Kansas, while sometimes difficult to operate in, at least makes the debt collector go through the steps of getting a lawsuit on file, getting a judgment, and then you can apply garnishments. So the key component, though, to the financial assistance policies and charity care is that before they can engage in any of that stuff, in Kansas anyway, obviously, again, the lawsuit triggers the right to get a garnishment. They have to take affirmative steps to verify eligibility before engaging in those collection practices. So they have to take a step or two towards saying, hey, look, I don't know if you can pay this bill. Here's our financial assistance policy, that sort of a thing. Under Kansas consumer protection law, that I feel like kind of dovetails with that. There's certain requirements in the Kansas Consumer Protection Act that a provider or not a provider, consumer and a supplier, excuse me, a supplier, and hospitals are considered suppliers. The courts have found that hospitals are suppliers of healthcare, and patients are consumers. But there has to be at least some level of understanding that the consumer can pay before services are rendered and that sort of thing. Obviously, we don't want people saying, well, I can't get healthcare here because you're too broke. But it sort of provides an avenue to say, hey, look, you didn't even bother to look and see if this person is eligible. You had a statutory duty, which is your duty under the IRS regulations to check this eligibility in the FAP. They have to bill accurately and properly. There's been some case law about, is it one line of billing for this? Is that considered two violations and all sorts of different things? But at the end of the day, they can't just be randomly, willy-nilly billing. That's a violation of the Kansas Consumer Protection Act. They do have to inform residents in their service area that the FAP is widely or is available. It has to be widely publicized. And there's not a lot of definition in necessarily what widely publicized means. Over the course of sort of looking into the case law and looking into the history of these sorts of things, nobody has really sat down and said, these are the four corners of the document that will tell you exactly what widely publicized means. Though there are certain requirements about language and that it's offered in and plain language versus the full policy itself. Nobody really knows exactly what widely publicized means. We do know, though, that if nobody in your county knows that this thing exists, that's probably not widely publicized. So, as I said, it's required to be available and easily accessible to all patients. Ideally, when they should be handing this over is at admissions. When you're signing all those papers, yes, I consent to have my leg cut off, or whatever it is they're doing. You should be getting a copy or at least information about the existence of the policy. The full policy must be available, and it has to be available at least on demand. They don't have to necessarily publish the full policy. From what I've found, they do on their websites. It's not a huge deal these days to publish something on your internal or on your own website and just say, hey, look, click here on this link, and that will get you to where you need to go. One of the interesting things is that I did find in some case law, not necessarily from Kansas, but around the country generally, is that if you don't include a pathway to view the materials, that's not considered widely publicized. So, for example, if you offer it online as a PDF, you also need to offer a way for folks to get the software to view that. Now, of course, Adobe Acrobat will read Microsoft Word, it will read rich text formats, it'll read PDFs, all those different things. But the key component there is having it online and being like, well, it's your own responsibility to find something to read this with, doesn't, in most courts' views anyway, doesn't quite reach that level of a widely publicized. You do have to include a plain language summary. And a plain language summary is sort of getting at the root of individual folks who may not be, I hate this word, but we use it in the law all the time, sophisticated. We're talking about folks who are highly educated, lawyers, perhaps, accountants, doctors, things like that. They may be able to very easily understand a dense and complicated financial assistance policy with all the different moving parts, like we need this W-2 and these forms and that thing over there. There has to be a plain language summary that's available. Typically, they're about a page, maybe a page and a half. And at a minimum, they need to be provided, again, according to the regulations, they need to be provided in areas of the hospital for admissions, patient waiting areas. The emergency room is a great example. People are coming into the emergency room and not necessarily worried about, well, can I pay for this? Although in America today, I do acknowledge many of us are probably sitting here thinking to ourselves, well, one time I broke my hand and waited to go to the emergency room because I knew how much it was going to cost. But the point is, where you are interacting with patients and where those documents are being exchanged, there should be a plain language summary, at a minimum, a plain language summary offered. And it does have to be offered in multiple languages as applicable. It's based on community needs. So some areas might have 3 or 4, maybe even more than that. For example, KU Med Center for sure has English, Spanish, Vietnamese, and I believe Mandarin, and a few other languages that are commonly spoken in the area, but don't necessarily have that full fluency. Those individuals don't necessarily have full fluency in English, and so they offer it in different languages. And the hospital has requirements for going through and surveying the individuals who are coming through the hospital doors to determine which of these languages need to be offered. I'd say in KCK, you probably need to make sure it's in English and Spanish for sure. A lot of other places are doing just English and Spanish on everything just because. As I mentioned, I was in Washington, D.C. recently, and every exhibit that I saw had an English and a Spanish description for all of the various things. So in order to reach that widely publicized level, there needs to be some alternative answer or some alternative languages offered. So if you think you would qualify for a financial assistance policy, if you can't pay your bills, and this turns into a collection suit, you can apply for the financial assistance application at any time. You can request it, demand it in writing, in full, so that you can see it, you can review it, and you can submit the application. And even if an individual has been sued for collection, the charity care can be used to show that care back in 2015 or 18 or 21 or whatever should have been free or discounted in the first place. It can be a great negotiating tool. It can be very helpful for folks who, maybe 10 years ago were struggling and didn't have money to pay their bills. Most of the policies are going to be looking at the affordability at the time of care. I don't know that there's a specific definition. I'm not familiar with one anyway that says it has to be at this moment of application or whether it's a look back. In my experience, it's been sort of a look back type of thing. So the hospital will ask for income information from that time period and use that to apply whether or not those services should have been charity care. Interestingly, as we've been talking about sort of the widely publicizing, there are some things that in their billing practices need to be included. For example, at the bottom of your bill, everybody kind of think back to the last medical bill you had, sort of in very fine print, very light gray, maybe at the bottom. It might say really small, having trouble paying your bill, call this number. Or trouble paying your bill might be on the back or the bottom. And it may be very vague terms. But the key component there is that it's going to be giving you the information to find out who you need to talk to get the financial assistance policy and the application. Even if you're calling those folks, the on the ground individuals collecting bills for the hospital or the doctor's office may not necessarily have knowledge about the financial assistance policy. But if you're requesting it, they really should be able to get you a copy of it. At a minimum, if the people you're talking to on the phone say to you, well, I don't know what that's about, ask for that rejection of, I don't know anything about this in writing. Obviously, I'm a lawyer, so I love everything in writing. It makes my job a lot easier when I'm arguing about, evidence or what somebody said. It's a lot easier when it's written down and their name is signed at the bottom. Like, well, no, it says right here that you said you don't know anything about the financial assistance policy. And so I think a key component there, like I said, is there is no harm to you at all or your clients at all to ask for an application. Just because you ask for an application doesn't mean you're going to submit an application. And the submission of an application for financial assistance cannot be the basis for denying care. So there's very low barrier to entry here, or like very low risk to asking for a financial assistance policy, and the benefits could be huge. I've had some clients recently where we're talking $5,000, $6,000, $7,000 worth of debts that are essentially erased. And this is not debt forgiveness. This is not a taxable event. It is just you couldn't pay for it. We're required to offer charity care. And so, when you have individuals who may be talking to you about a debt collection that's going on, look and see, is this a nonprofit hospital? Is this Advent Health? Is this KU Med Center? Is this one of these community-owned hospitals? They're going to have that financial assistance policy, and it could be a huge boon for your clients to have that debt just erased and not really have any consequences for that. So that's nonprofit hospitals and sort of dealing with, the charity care aspect, the idea that they are there for the community benefit, not to be lining the pockets of shareholders. This is a totally different ballgame in for-profit hospitals. Essentially, a for-profit hospital, as I was talking about at the beginning, is just like any other business collecting a debt, with a few small caveats. And we'll talk about those in just a minute. But under the law, for-profit hospitals are not required to offer charity care or discounts or payment plans or any of that. There is nothing that's in the law that says you have to offer charity care as a for-profit hospital. They do often offer these things, though. My spouse works in healthcare. I'm very aware that the hospitals are charging huge amounts of money more than what it actually costs them to do things. And so they do offer pretty steep discounts on certain things. So for example, there's often a self-pay discount. And all this really requires is for you to just tell them, hey, I'm paying myself, or I want to pay this early, or those sorts of things. To get these discounts, you just kind of have to ask for them. There is, I think, anyway, in American culture, sort of, or US, I shouldn't say American, I should say US culture, they sort of, well, the price is the price, you get what you get, don't throw a fit. And I have found in working in the debtor defense space, and specifically in these medical debt cases, that is just absolutely untrue from a business operations standpoint. Many hospitals, many debt purchasers, many collection agencies are very willing to negotiate. But oftentimes the individuals who are the target of the lawsuits or the collection actions are not. And they sort of rely on that. And I wanted to call out specifically a thing called a hardship application. I've only seen this at a handful of hospitals. I've seen it a little more frequently with credit card debts, or sort of maybe payday loans or title loans, those sorts of things where you can file a hardship application. I'm not entirely sure what the regulatory requirements are under this. I haven't had a lot of time to dig into them. And I found that they're not necessarily offered everywhere. And they typically require pretty intimate knowledge of the regulations and the rules for the debt collector generally. And this is especially true of for-profit hospitals. So you can always call and ask about them. They might be cagey. They might be sort of like, well, I don't know. And maybe on Tuesdays we do. But I think sort of adopting a slightly more European mindset about the things that we purchase on a day-to-day basis, or the services that we ask for, negotiation should be a little bit more or should play a bigger role in how we pay for those services. So there's no harm in asking. And I know a lot of folks on here are going to be sort of case management and case worker, social worker kind of vibe going on. So you can flex that expertise, that understanding of, I'm advocating on behalf of someone for something. I'm not being a legal advocate necessarily, but I'm looking for resources. You guys know how to look for resources, and the hospital has them. They just might be playing it pretty close to the chest. Again, there's no harm in asking. You're not tipping a hand about anything. You're not running afoul of any rules or regulations that I know of, to just ask, to just inquire. Is there a hardship application? Is there some alternative method of billing for this that we can talk about? Is there a self-pay discount? Is there a prompt pay discount? Are there discounts for, having my primary care physician as part of the same hospital network? Asking about those things is never a bad idea. I've had limited success with hardship applications. The biggest ones I've seen where these sort of hardship applications are successful is in credit card situations. Just the other week, we were working on a case where a hardship application was probably really the only way we were going to get any relief. And they are involved, I will say. Hardship applications are going to require about the same kind of input as a financial assistance policy or charity care application is going to have. They're going to want pay stubs. They're going to want information about any lawsuits that might be pending, or, where do you live? Who lives with you? How long have you worked at your job? All those different kinds of things. But at the end of the day, the risk there is low. It may help them serve you if they decide to sue. That's very true. But at the end of the day, if it gets you to a place where you're paying 20% less, or maybe even 50% less of the bill in total, that can represent a huge success for an individual or a family who's struggling month to month to pay for things. If you're talking about a $2,000 bill and you cut that in half, now it's only a $1,000 bill. So even though the for-profit hospitals don't have to offer charity care, they also know that they're charging an insane markup on these things, and they can offer pretty steep discounts. By way of example, I do know that North Kansas City Hospital self-pay discounts on radiology are above 50% for many of the services. If you go over there and you self-pay for an MRI, your explanation of benefits for the MRI will say that they billed your insurance for $40,000. Well, if you do a self-pay, it's $150. Like, there's no rhyme or reason. So there's never a harm in asking for any discounts. Like I said, if you're concerned about it, give us a call. My phone number and the phone number for KLS will be at the end, and maybe we can help you figure that out. But there's no harm in asking. So what are some of the things that you can do to protect yourself if you do get sued by a for-profit hospital? Again, remember, the financial assistance policy does not apply to for-profit hospitals. I know I keep hammering that, and it is sort of like kicking a dead horse, but it's really important distinction to understand. The number one thing that any individual that you may be working with can do to protect themselves against debt collection is to show up. Most of these collection firms operate on what's called a volume-based strategy. Their whole goal is to get 30, 40, 50 cases on a docket and then just sit there and say default judgment, default judgment, default judgment, default judgment. What that means is the other side didn't show up to contest my allegations, so that means I win by default. And that's their whole strategy. They are not prepared to have any level of pushback. They don't typically have any of their documents in a row. They often are, you might call it dubious levels of service of those lawsuits on people. And so the showing up and just saying, hey, I don't agree to just pay this bill without them showing me something, can throw a wrench in that whole plan. And if they're spending time working on your case, that's time they're not spending getting default judgments on other cases. So they're usually happy to try to dispose of them, the ones that squeaky wheel, as soon as possible. So the other part that folks can do is reach out. Again, they don't have FAPs. They do offer payment options. They offer discounts, other ways to offset bills. Being in contact with the billing department is always a better choice than being in contact with opposing counsel. If you are a lawyer, great, welcome. It's a lot of fun being a lawyer, but if you aren't a lawyer, negotiating with a lawyer on the other side can always be intimidating. So if you've got an opportunity, reach out before you get to that point of a lawsuit has been filed. So one thing people ask a lot about, when it comes to debt collection lawsuits, and especially in the medical sphere, is whether or not medical debts can be reported on your credit report. Now, in 2025, the federal courts determined that the rule that had been passed by, I think it was the Consumer Financial Protection Bureau, the CFPB, that rule that said that they can't report medical debts on a consumer credit report, the court found that unlawful. It was in 2025, it was about a year ago. So federally speaking, there may be rules in the states, and I'm not an expert on the Consumer Financial Protection Bureau's regulations when it comes to consumer credit reporting. But federally speaking, they don't have a requirement to not do it. The big three, Experian, Equifax, and TransUnion, claim that they don't allow hospitals and debt collectors to report debts unless they're older than a year and greater than $500. I have not found that to be true, but they claim that that's what they do. They won't accept them unless the debt is older than a year and is greater than $500. I've seen plenty of folks who come in with credit reporting issues that show, there's a $445 judgment against you from 2026. No, well, it's not a year old, and that's less than $500. So what's it doing on there? Certainly, those big three. Again, it's the big three. The other ones, there's lots of other ones, FICO, and I don't know, but Experian, TransUnion, and Equifax all have dispute resolutions available on their websites, available on Credit Karma. That's an app you may be familiar with, but it makes it easy to sort of navigate to those places where you can find the disputes. If it's less than $500 or it's less than a year old, certainly make that application and it can come off that credit score, which can change things for folks. You're talking about really enhancing your borrowing power and maybe changing some interest rates for individuals. Of course, I'm not a big fan of carrying debt if you don't have to, but just note that federally speaking, there's no protection to reporting a medical debt, whether it's for an actual procedure or whether it's for co-pays and that sorts of thing. So one of the other things that happens for a lot of folks is you may get the judgment against you, but your judgment proof. Folks on SSDI and SSI may already be on Medicare and Medicaid. So the money that is paid to you out of those two things, Social Security disability and Social Security supplemental income, can't be garnished. Though defending them can be sort of difficult. We can help with that. Please give us a call. We have some folks who are quite skilled at defending against that kind of a thing. And it requires some key points. First being that the money has to be separate from any other money. And I tell clients this pretty often. You get a birthday card with $20 in it, that cannot go into the same account as your Social Security. You get tax refunds or payday and title loans, cash advances from credit cards. All of those funds commingled together can cause a real problem with whether or not the account that has your Social Security in it um, becomes attachable, and they can start garnishing on that. Another key point that a lot of folks see happen, especially individuals who maybe don't have the easiest ways of getting to and from work or dangerous jobs. If you are involved in some sort of a lawsuit for the injury or the illness that brought you to that hospital, to that provider, the hospital can put a lien on those proceeds from that lawsuit to recoup their costs. So, although you may be on SSI or disability at this point, the lawsuit that is being filed in order to collect money damages, the hospital can put a lien on those proceeds, recoup their costs for treating you. Just sort of understanding that judgment proof means I don't have money that you can garnish, so you can tell me all day that you are going to take it, but you can't. So go ahead. I think it's sort of a last line of defense for a lot of folks. I wouldn't recommend opening with that, sort of realizing like, hey, at the beginning, you probably don't want to just tell them, yeah, judgment proof, go ahead and sue me, be polite, all those sorts of things. But just keep it in mind that folks who have no income whatsoever or who are only on some sort of Social Security may be insulated against the collection actions, including the garnishments and liens and that sort of thing on the house and bank account, that kind of stuff. The lawsuits, though, if you're suing somebody for running you over, they could probably take a good portion of that to pay for your medical care. So, what are some do's? So first and foremost, check again. I'm going to keep beating this horse to death. Check and make sure that this hospital and the provider is a nonprofit. Remember that the NPOs, the nonprofit hospitals, must offer a financial assistance policy. If they are a 501c3, they are governed by 501r. There's no in between. Of course, I'm a lawyer, so good general advice: read all the terms of any agreement that you sign. I recognize, though, that this can be hard in an emergency room situation. If you've got a kid who's hurt, or if you yourself are injured in some sort of an accident, or have been attacked, I mean, that would be horrible. But, some victim of crime of some level, that can be especially hard to be like, oh, yeah, I'm supposed to. That guy, Andy, told me I totally need to ask for a financial assistance policy. Not what you're really thinking about at the moment that you're visiting an emergency department. Of course, after all that's over, maybe you're stabilized, maybe it's a couple of weeks or months down the road, and we're starting to say, hey, you got to pay the piper. Ask for copies of all the documents that you signed so that you can review those. There's going to be information in there, little tidbits that the hospital hides to be compliant with their regulations, but can give you directions on where to ask and what to ask. Always demand a copy of the financial assistance policy. I do it at every hospital that I go to. I don't go to a ton, but I play hockey, and I have most of my life. So I find myself in the hospital a little more often than I would like, especially as I get older. But even when I know that I don't really need the financial assistance policy, I want a copy of it. I have personal copies of financial assistance policy from the three major hospitals, nonprofit hospitals here in the area, and I just have them on hand. You never know what's going to happen. It's good to have them around. I say maintain contact with your billing department. As we kind of talked about a few slides ago, it's way easier to talk to somebody who's not a lawyer trying to sue you than it is to talk to a lawyer who's trying to sue you. I'm a lawyer and I don't like talking to other lawyers who are suing my clients. I do it because I think it is the best way to get anything done, but it's always a cat and mouse game. So where possible, when you're talking with the billing department, get stuff in writing. Emails, letters, text messages. I'm not as big on text messages. They don't seem to always convey the full breadth of whatever's happening, whatever decision has been made. And they tend to come in weird orders and all kinds of, like the second half will come in after the first half. And it's all, if you can get it in an email or a letter, that's ideal. But any writing will suffice. Always ask about costs. Again, I mentioned my husband is in healthcare, and one of his biggest pet peeves is that almost no hospital is actually compliant with the cost and the transparency laws for the costs of medical care. Ask early about those discounts. Make sure you've got your insurance, Medicare, Medicaid info. And this one is just sort of like general life advice. There's not like an actual um, legal thing behind it. And it does directly come from my husband, who puts this in my ear all the time. Engage in the correct level of care. ER versus urgent care versus clinic/primary care. Just make sure you understand that the ER is for those things where if I don't see a doctor in the next hour, I'm going to die. Like literally die, not like, oh my God, I'm dying, but literally dying. Urgent care is for something that's, I got my wrist hurts, or as you can hear, my nose is all plugged up. Like I need to see someone today, but I can't wait a week to get in to see my primary care. And then finally, clinic versus primary care, or clinic/primary care. The reason I suggest this is because ER is the most expensive, primary care is the least expensive. So all on those levels, a 50% discount on anything is always great. But if it's a 50% discount on a $100 bill, now you're only talking about owing $50, whereas your ER bill might be $5,000. So just think about your level of care that you need and keep that in mind. Some don'ts. Do not miss court dates. As I said, not showing up means you lose. Do not totally ignore those bills that get sent to you. I know they're complicated. I know they're long. If you've got clients who are struggling with these kinds of issues, encourage them to bring bills in so that you can see what's going on. Because you can use those bills to get those little tidbits that I was talking about. Is there a self-pay discount? Is there a prompt pay discount? Is there, a financial assistance policy? Is there a hardship application? Those little tidbits are going to be hidden in those bills. And again, I'm not attributing malice. I don't want to speculate about why the hospitals are doing it. I think it comes down to greed, but they hide those in there for a reason. They have to tell you about them, but they don't have to like kick down your door to make it happen. Where possible, I always tell folks in the law, outside of the law, anybody who asks me, avoid credit-based repayment plans and offerings from hospitals. It's mind-boggling to me that you can go into a dentist office, a hospital, a vision care center, and there's care credit, Fortiva, title and payday loans just down the street, Sezzle or Sunbit Finance. The problem with those is that now you're dealing directly with a firm whose whole goal in life is to collect interest. And they will fight tooth and nail for that and make it really difficult. Where possible, avoid the credit-based repayment plans and offerings. I understand that in modern America and Kansas and across all 50 states, that's not really possible for most people. But these sorts of finance options come with interest. Typically, hospitals do not charge interest. They don't want to be considered a bank, so the hospital itself is not going to be charging that kind of interest on medical bills, but the care credit is, Fortiva, title and payday loans. These folks will charge interest if you miss your payments. If you are sued, don't simply come into court. The judge is going to ask you, do you admit this or not? Don't just admit it outright. You have no obligation to do so. Lawyers spend a whole lot of time talking about a prima facie case, talking about establishing our burden of proof and all those sorts of things. It's on the hospital to prove, it's on the debt collector to prove that you have to pay the debt. If you go in and admit it, if you go in or you don't go in at all, or you don't respond, you're handing them an easy payday. There's no reason to just straight up admit because you want to be agreeable. These people, the ones who are suing for these debts, are not agreeable themselves. Don't give them any more credit than is due. Don't try to fight it alone. Call Kansas Legal Services. Call social workers or other case managers that you may know. Look up resources. There's no reason to fight these sorts of things alone. There's plenty of resources out there in the community for folks who are looking to help with this kind of advocacy. And I think it behooves you to connect with those. Don't leave home without your insurance card. I've had a handful of cases where it comes down to, well, we had insurance. Oh, you did have insurance. Leaving home without insurance is always, again, it sucks that it's the American system, but it is the American system. If you have Medicare and Medicaid, make sure you have that information available when you're getting care. And the big one again, or the last one, kind of like the previous slide, this is just sort of general good life advice. Don't sign anything unless you've read it first. Again, with the caveat that I understand if you're in an emergent situation where you've been hit by a bus and you don't have any choices on that, get those copies afterwards. But until you've read something, I would not suggest writing your name that you agree to it. And I think that leaves us, well, I was a little faster than I expected. But I think that leaves us with some time for questions. Again, my name is Andrew Kent. I'm staff attorney. You can see our intake information and our local office line for the KCK office. Happy to take any questions if anybody's got them. Going once. Going twice.
Got a question, Andy.
Yes, Joy, please go.
I may have missed it, but how do you tell if a hospital is for profit or not for profit?
So typically, I mean, that can actually be kind of a hard determination depending on, like, a lot of times they change hands a lot. But what you're going to be doing is looking on their website for keywords that sort of indicate that kind of a thing. We're a religious-based hospital, for example, like the St. Luke's type of places or St. Bethany's, or whatever. Those religiously affiliated hospitals are almost always nonprofits. You can go online to the IRS website and search for certain documents that have to be filed. And if that hospital has filed like a Form 990, then they are a nonprofit. You can also use the Kansas Secretary of State's website. So even if they are a 501c3, they are required to have their licensure and all that stuff through the Kansas Secretary of State. You can just, it's got a very handy, although maybe a little aggressive search function, where if you search it and the name matches up with lots of different things, you're going to get lots of hits. The KU Physicians Group is actually a perfect example. If you type into the Kansas Secretary of State's website, the KU Physicians Group Incorporated, you get 3 or 4 hits, and 2 or 3 of them are for-profit entities, but you got to kind of dig through and realize that those for-profit entities actually no longer exist. And the KU Physicians Group is actually its own 501c3. But it is not the same as the KU Medical Center, which is actually, I mean, it's a 501c3, but it's also its own municipality. That gets complicated, but it's always safe to use the Secretary of State's website. They do have to designate if they're nonprofit.
Thank you. Now, what if you don't know how to do all this technology stuff and go on the computer? How do people who aren't savvy with technology, how do they find out information about the hospital?
Like I was saying in some of those earlier slides, it never hurts to just ask. If you're on the phone with someone in the billing department, you can certainly ask those questions. I don't think there's anything, I don't think there's any sort of analog method to do so. They don't have to put it on the front door. They don't have to have it in their name. But when you start to look at a situation, you think to yourself, well, okay, they're associated with a college. Typically, colleges are nonprofits. Typically, I know that's not true for all of them, but typically those are nonprofits. Community-based hospitals usually are going to have on their website in their about section, information about how the hospital came to be. If you've got an individual who's maybe a senior, and I'm not being ageist in any way, I'm just saying folks who have been around longer have seen more things happen. They might have some historical knowledge of, oh yeah, in 1981, the county bought the hospital. And that can be your indication, is just sort of knowing maybe the history of the area. In terms of, like I said, some sort of physical notification or real simple way, I can't really think of one, because there's nothing that's required. And most of them are going to be, like I said, affiliated with a religious organization, affiliated with a college or university, those kind of places, or affiliated with a county government. Those are going to be nonprofits. Any other questions? Good question, though, Joy. Thank you.
I know that there was mention of like dental and medical. So does this apply to dental as well, or are a lot of dental offices similar?
That's a good question. So the 501R regulations apply to hospitals. And I think you might be having a bit of a stretch to say a dental practice is going to be a hospital environment. That's not to say that there aren't nonprofit dental programs out there. There are many of those. And I think if you're operating a dentist office as a nonprofit, you're going to be seeking to serve a population that doesn't have a ton of money. And so you're probably going to have these options anyway. But I can't think of off the top of my head, individual sort of smaller practices that are going to have the financial assistance policies. If they're nonprofits and they could qualify as a hospital, then you might be looking at having the requirement for the charity care. Certainly the size, and there's a whole lot of regulatory framework about what defines a hospital. I just have a hard time imagining a dental practice qualifying as a hospital for the purposes of financial assistance policies.
Thank you.
Yeah. Any other questions, comments, concerns, funny limericks? Oh, going once, twice, 3 times. All right, sold. Bella, I'll let you take it from there. However, folks can get a copy of this. I'm happy to send the slides along with the resources, links to the resources that I use to put these together, and a few other things. Bella, if you want to share those out to the group
Yeah,
or to the website.
we'll post go ahead and send them to me, and then we will also post the webinar on the KSHC website and on our YouTube.
Great.
That should be up tomorrow at noon.
Awesome. All right, I'll make sure I get those to you today.
Awesome. Thank you so much. And thank you for presenting.
Yep. Thank you all very much.
Have a great day, everybody.